I welcome all the participants in the today's study circle meeting. Today's topic is implication of decision of Honorable Supreme Court on Section 148, and this is the burning topic all over the country. And we all professionals are analyzing the impact of this Supreme Court. Today, we have our own who is the chairman of the session, and we have two learned speakers from our own Kolkata, Advocate Narayan Jain and Advocate S.M. Surana ji, who will deal with the subject. Now I request Advocate Kamal Jain to please address the keynote address. Over to you, sir. Kamal ji.
Thank you. Good afternoon.
मुझे आवाज नहीं आ रही है,
गलत नेटवर्क इशू होगा,
डिस्कनेक्ट हो गया उनका।
ओ हाँ, आगे सर अनम्यूट कीजिए। हाँ सर।
हाँ, good afternoon. Warm welcome to all my past presidents, seniors, friends, delegates for joining this webinar. Section 61. On 20th March 1921, a circular was issued by Civility for amendment in Section 148. A new Section 148A was introduced from 121, where the time limit of 6 years was reduced to 3 years. And if the escaped income is more than 50 lakhs, then the time limit for reopening of the case is 10 years. Again, a circular was issued for extension of time to issue the notices under Section 148 of the IT Act. That was from 1st April 21 to 30th June 21. During this extended time, more than 90,000 notices were issued. Approximately 9,000 writ petitions were filed to different high courts, that is Allahabad, Calcutta, Mumbai, Delhi, Maharashtra, Rajasthan. Against the order of Allahabad High Court, Department moved to Supreme Court, invoking the extraordinary power under Article 142 of the Constitutional Law. Supreme Court passed landmark order on Wednesday. Honorable Supreme Court directed that reassessment notice under Section 148 of the unamended Income Tax Act, which were issued beyond 1/4/21, the effective date of amendment of the said provisions by the Finance Act 2021, to be deemed to have been issued under Section 148A of the IT Act as substituted by the Finance Act 2021, and the constitute as so-called notice in terms of Section 148A. The assessing officers within 30 days provided to the respective assessee information and material relied upon by the Revenue Authority, so that the assessee can reply to the so-called notices within 2 weeks thereafter. We are with us Sri R.S. Upadhyay, former CCIT, as chairman, senior advocate Sri Sumirmalji Surana, and advocate Sri Narayanji Jain as speakers of today's webinar. They will share their views regarding the decision of Supreme Court. Without taking more time, I'm handing over the mic to Mahendra ji for further proceeding. Thank you.
Thank you, sir. Thank you very much, sir. As we all know that today session chairman is our own Upadhyay sir, and before his remarkable note on the issue, I am duty bound to introduce himself. Mr. Upadhyay joined IRS in 1985, worked as ACIT DTIT Assessment Headquarters Vigilance Investigation between 87 to 95 at Bhopal and Indore, came to his own choice into Kolkata in 1995, worked as DTIT Investigation between 1995 to 97, JCIT Special Range between 97 to 2000, Administrative Range 13 and 15 between 2000 to 2001, Central Range 5 and 6 between 2001 to 2002. Opted for DT October 2001 to February 2006. On promotion, retained as Director DTRTI 2006 to 2008. During his tenure as director, the RTI Kolkata was declared as Center for Excellence in Real Estate and Recovery of Tax. At DTRT office Kolkata was transferred to Mumbai and was made dedicated CIT appeal for transfer pricing appeal of Mumbai region. Decided case of MNCs like Unilever, Procter & Gamble, L'Oreal, bank like HSBC, Citibank, RBI Dues Bank, IT measure like TCS, Accenture, Capgemini, pharma measure like GlaxoSmithKline, Merck, Pfizer, Lupin, was transferred as General Director Vigilance West in 2012 and supervised the vigilance activity of state of Maharashtra, Gujarat, Rajasthan, MP and Chhattisgarh. In June 2015, was transferred back to Kolkata as Principal DIT Investigation, where he is in the charge of enforcement action of Department Investment Manager. Now, I request Shyam to offer a digital flower bouquet to our session chairman, Sri Upadhyay ji, sir. Sir, please accept as token our respect and regards.
Welcome,
Thank
sir.
you, thank you, thank you, thank you. I
Now
appreciate that.
Now I, sir, hand over the proceeding to you, sir. Over to you, sir.
Thank you, thank you. Respected Mr. Jain, Mr. Agarwal, Narayan Jain, and Mr. Surana, if he has joined us yet, and so many familiar faces which I'm seeing on screen. I'm happy to be here sharing this session. I was looking forward to live audience and interactions, and which makes a personal feel and in physical form. But then, because of whatever reason, it did not happen. You see, my association with DTPA is a very long one. When I came in 1995 to Kolkata, the first person I met as DDIT investigation coordination was Mr. S.K. Sultania. And Mr. Sultania was such a fine gentleman. He offered me to help if you need a gas and all. Later on, so many DTPA members I have come in contact. Very nice people, caring people, and who have showered lot of affection. I have retired in 19 October. Still, the DTPA keeps on, inviting me. In fact, in two of the DTPA conferences, the annual conferences, which is very prestigious, I was a speaker. I spoke on 271(1)(c) in ITC. Normally, the DTPA holds its annual conference in Taj. And one was on joint development agreement on 2000. One was a joint development agreement on 2016. And at that time, if DTPA members, some of them may recall, I had highlighted that in the case of joint development agreement, if the landowner hands possession, he may be in trouble. Though at that time, people did not take me seriously. But later on, the amendment came in 2017, and where it was realized, it was indicated that, well, after the handing over. So prior to that, the law remained. So that was there. Now, DTPA is one of the better organizations. We have a number of professional organizations in Calcutta. And DTPA is the most recognized, most respected because it spreads awareness. It's a lot of bonding between tax advocates, chartered accountants, and tax consultants. Now, before we come to the topic, let me say that the background of why it is 147, 148 in the statute. What is the RAP 263 is the machinery provision of the Act. It is meant to implement the substantive provisions. It is like a CRPC to Indian Penal Code. Now, the main rationale behind 154, 263, 148 is that if a legitimate revenue to the government has been because of omission, commission, mistake, negligence has not been collected in the first place, then there should be a provision to recoup it. Basically, what it says is that there is no vested right to a mistake. Just because the department has failed to tax in the first place or did not have the information in the first place, that does not mean that the taxpayer is getting full blanket relief or a blanket cover, that nothing will happen to it. So every fiscal statute has a section which is in the nature of 147 to recoup the revenue, 154 for mistakes and record and other things. However, the issue lies in implementation. Now, while on the one hand, section 147 is meant to recoup the revenue which is due to the government, on the other hand, it militates against and vitiates against the principle of finality. See, in any law, there should be finality. Whatever there is a law, there should be resolution of dispute. And if there is no finality. People will lose faith in the law. People we may not, have a dent. And that is why the courts have taken a very strict view that reopening should not be done in a matter of routine. It is a serious matter. And even the statute incorporates certain safeguards. But the courts have been very strict that based on the principle of finality, that you simply cannot reopen on the basis of on a just a non-serious routine manner. In fact, I was reading somewhere that out of 80% of the writs in the country is because of 147 as it existed, 5% for recovery, and 15% for rest of the matters. So you can imagine that the maximum litigation is because of 147, 80% of the writs. I mean, not only this writ because of this, notification of the government. Earlier also, maximum writ was because of 147. And the reason is not far to seek. 147 has so many limbs: recording of reasons, recording of independent reasons, no inquiry and roving inquiry, reopening not to be done, just to do roving inquiry within 4 years, after 4 years, jurisdictional issue, the time of, so there's so many issues are there, that approval, application of mine. That is why the litigation is very high as far as 148 is concerned. And while on the other hand, the litigation is high, the government also keeps on, making amendments. If you look at 147 history, first amendment was made, major amendment was made in 1987 Direct Tax Amendment Act, where, which was far reaching. They removed the, in consequence of information in possession, added reasons, recording of reasons. They merged 147A and 147B. They removed the distinction between scrutiny and summary assessment. So first major, amendment and wide grouping was done in 1987, direct amendment. Then the next was done in 2009, when explanation 3 was added to the retrospectively from 1989 to say that if a case has been reopened, then maybe the reason recorded for one particular reason. But if after reopening, the taxpayer, the assessing officer can look into anything which he wants to do it. That means even those points which were not recorded in reason. This was subject matter of lot of litigation, jet airways, and the controversy remains. But what has happened after Finance Act 2021 is really major. They have now abandoned the old 147, 148, 149. They have introduced 148A. Earlier, search and seizure was assessments and their escapement was being done in a separate manner, 153A to C. Now that also has been merged with this beginning of 1/4/2021 searches. So, as it is, many of you know that in search and seizure cases, most of the searches in Bengal, Calcutta takes to take place because of share capital, loans, which was already there in the balance sheet. So the High Court said, what are you going to find? It is already there in the balance sheet. So if you do not get any incriminating material in form of cash exchange and then getting that loan, then you cannot do 153 ABCs. As it is, department was losing many of the cases because of the fact that very few cases yielded incriminating material. So now that also has been gone. So that is one area. And then more important is the fact that that reasons to believe has been given to go by. Now it is he has information, and information also has been defined. It is based on some risk assessment strategy of the CBDT, and they have identified certain areas based on their algorithms, data mining, what do you call this thing? So even what is information also has been identified in many cases. Then expression has come on representing an asset. When in earlier this was not there. Now in 147, 148A, 149, the sections, corresponding sections or accompanying sections, asset representing an asset means even a share capital which is not an asset, a loan can also. So a lot of litigation may start. But most important was that there was no direct assumption of jurisdiction. 148 said no, do some pre-verification. That was the major change. See, earlier on, once you start the proceeding, then you have to fight it out. Now they said, no, do some inquiry. 4 preconditions were added. And those 4 preconditions were added. First you do those inquiries and then come to conclusion. Once you initiate 148, then it is, it normally takes so that was introduced in 148. That was a major development. And that is because if many of you may have seen, there was an SOP of CBDT dated 10th January 2018, where the CBDT had said that please do these things before you issue a notice. But that was only an administrative circular. And most problem was because the investigation wing, which generates 95% of this 148 or 148A now, 147, they used to send the information in the last week. So the officer has no time to do those inquiries, which was given in that CBDT circular or direction of 10th January 2018. Now, those 2018 direction has now been made part of 148A. Now 148 lays down. Earlier, you could not have challenged that administrative circular because administrative circular may not be legally enforceable. But once it is a part of the act, then you can challenge. And that is why the writs have happened there. Finance Act 22 has diluted some of the provisions. I will not go into that. Finally, I come to this notification and which says that, there were 2 time zones. While the time of issuing notices was extended from 31st March 2021 to 30th June 2021, the law which started was of Finance Act 20, which said that you cannot do that. You will have to follow 148A. So there was a clash, 2 time zones clashed. And obviously, it went to the taxpayers went for it, and they challenged that there is a notification which is an administrative measure, and there is an act of parliament. There is a supreme legislation which is the act of parliament, and there is a delegated legislation which is the what you call of the CBDT. So tomorrow anybody can make law if this is what it happens. And they won the Bombay High Court, I think Calcutta High Court, Allahabad High Court. All the writs went in the favor of SSC, except perhaps Chhattisgarh. Now what happens? So many cases involved, 90,000, like Mr. Kamal Jain mentioned, and 9,000 writs were there. Law, Supreme Court, what the Supreme Court normally does, it just interprets the law. It does not make the law. Law is made by the parliament or by the state legislature. It interprets whether it is as per constitution and other things. But Article 142 gives power to the Supreme Court to make the law. Now the issue was so big that I believe, and I should say, that maybe government also, nudged them. No, bail us out, bail us out. Now, they could not have defended that as an appellate jurisdiction. Supreme Court would have given the same decision which Calcutta High Court, Bombay High Court, Allahabad High Court gave. Because supreme legislation, a subordinate legislation cannot bypass. But under 142 article, they can make a law. So in this case, in a very exceptional measure, which is a very rare situation, when I have not seen in a Direct Tax Act, Article 142 being invoked. That is why, because the government, I believe, nudged the Supreme Court that please, you make the law under 142. Our law, could not be sustained. So they passed the order on 4th of May, and we are here for that. Having said, giving a brief introduction, now I have 2 eminent speakers today, which are there in this Zoom meeting. One is Mr. Narayan Jain, and one is Mr. Surana. Both of them are very experienced, very knowledgeable people, and I have benefited from my interactions with them. And I'm sure now they will say what should be the strategy for the taxpayer, how they will guide their clients, that what strategy to be adopted, how to go about it, what are to be things to be done. So with these a few words of introduction, giving the background rationale of 147, the history of amendment, I now invite Mr. Narayan Jain to start the proceedings and highlight and guide the professionals in the manner in which they can take their matter further, guide their clients aftermath of the Supreme Court decision. Mr. Narayan Jain.
Mahendra bhai, your voice is not.
I will request Sumit Bihani to please read the profile of our learned speaker, Narayan ji. Sumit.
Yes, we are. Right. So I take an opportunity to introduce our speaker Narayan ji, though he does not require any introduction among us. Mr. Narayan Jain was born in August 13, 1957. After completing his LLB and LLM, Master in Law from Calcutta University, Sir has been practicing as an advocate, mainly in taxation. Sir is a visiting faculty at IIM Kolkata, National University of Judicial Science, NUJS, ICI, ICSI, ICWAI, and various institutes in Kolkata. Sir has authored few books like How to Handle Income Tax Problem, Income Tax Pleading and Practices, Ready Reckoner for Business Expenditure, Tax Treatment of Cash, Credit and Unexplained Investment, Sir is also a member at the editorial board of the famous journal called Selected Orders of IT80. Sir has contributed several articles in forums like the Telegraph, Anand Bazar Patrika, Sanmark, Financial Express, Asian Age, Money Today, ITR, Taxman, Corporate Professional Today. And sir is a regular speaker on channels like Doordarshan, ETV, Taza TV, where he has deliberated on topics of income tax as well as social science, current social political issues. We welcome sir. Thank you, sir.
Now I request Shyam to please offer a digital flower bouquet to our lovely speaker Narayan ji, sir. Sir, please accept.
Thank you, thank you.
Welcome, sir.
Received flower bouquet.
And all the members are requested to please share your name and membership number in the chat box. Over to you, sir.
Can we begin?
Yes, sir.
Respected, most learned friend, philosopher and guide, Sri R.S. Upadhyay Sahab. Even when he was in the investigation wing or thereafter Chief Commissioner of Income Tax, we could freely meet him. And he never gave us the impression that he is on such high chair. So we remember all those occasions and we are expressing our gratitude, sir. And my elder brother, Sri S.M. Surana Sahib is with us. Whenever any forum invites me, I first think of also inviting Sri S.M. Surana ji, because that makes my cause easier. And he adds with his brilliant knowledge many useful things. So it is not only that today I am as a speaker, but I am also a learner. From Upadhyay Sahab and from Surana ji, I am here to learn so many things. Whatever little I know on the topic which is fixed for today, I will share with you. You see, there are many issues relating to this order which has been passed by the Honorable Supreme Court. And my comments are with due respect to the Honorable Judges of the Supreme Court. And now that the Honorable Judges have decided something, the whole country is to abide by that, unless until there is a review of that. However, we all expected that the judgment of various high courts, except one, which favored the taxpayers, and rightly so, even the Honorable Supreme Court in its order has also said that we are in agreement with the high court orders. I will come into detail about that. So we were all hoping that whatever is lawful will be approved by the Honorable Supreme Court. And what I am saying is also based on the Supreme Court judgment earlier. You see, the Honorable Supreme Court has said that there might be a bona fide mistake, bona fide belief. And I will give you many reasons whether there could be any bona fide mistake. The whole case, I will say, that was misrepresented on behalf of the Union of India in the Honorable Supreme Court. I first come to a civility instruction which was issued on 10th of December 2021. And there, this was relating to this issue of notices under section 148. The heading says that it is regarding uploading of information on the VRU functionality on inside portal. What is VRU? Is verification report upload. That is called VRU. So this was issued only for that purpose specifically. And there, you see what has been said in paragraph 5 of the instruction issued by the Central Board of Direct Taxes. I will read it for you so that you see there should not be any confusion, neither in the mind of we the tax advocates, tax practitioners, nor in the mind of department, nor in the mind of court. When the board is so clear in issuing the instruction as to what can be done and what cannot be done, then where is the scope of any confusion? You see this para 5 of the civility instruction dated 10th December 2021. It says, as per the provisions of section 149(1)(b) of the Act, in specific cases where the assessing officer has in his possession evidence which reveal that the income escaping assessment represented in the form of asset, that is as per the amendment made by the Finance Act 2021, amounts to or is likely to amount to 50 lakh rupees or more. That is the copy from the amended section 149. It says that notice can be issued beyond the period of 3 years, but not beyond the period of 10 years from the end of the relevant assessment year. Further, the notice under section 148 of the Act cannot be issued at any time in a case for the relevant assessment year beginning on or before 1st April 2021 if such notice could not have been issued at the time on account of being beyond the time limit prescribed under the provisions of the clause small b as they stood immediately before the proposed amendment. As per the explanation provided to section 149 of the Act, the term asset shall include immovable property, being land or building, or both, shares and securities, loans and advances, deposits in bank account. So here the Central Board of Direct Taxes was fully aware as to what are their limitations. And in this, in immediate next para 5.1, they say, in view of the above, means what I have just read, in view of the above, it is directed that the information pertaining to assessment year 2015-16, which requires action under section 148 of the Act, shall be identified and uploaded on the VRU functionality on Insight portal only as per the provisions of section 149(1)(b) of the Act. And at the end, later on in para 6, it says that whatever information or documents are to be uploaded on the VRU, those, it was advised by the board that those are to be uploaded and this exercise is to be completed by 20th December 2021. So this is to analyze the position of assessment year 15-16, that the notices, CBGT was aware, notices as per law could not be issued beyond 31st of March 2022. And after this, before this rather, on there was another advisory of the CBGT of 4th of March 2021, where they directed that whatever notices are to be issued, those should be issued by 31st March 21. My simple question is, who makes the amendment to the Income Tax Act? Who is responsible? Is it the Ministry of Finance or the Home Ministry or Defense Ministry? Who does it? And if the Ministry of Finance does something, then CBDT, the Revenue Secretary, and all functionaries of the Finance Department, they are all involved. And this Finance Act 2021, the budget 2021 was not only presented in Parliament, not only approved in Parliament, both houses of Parliament, but it got the presidential assent also before 31st March 21. And where is the question of confusion? This law, Finance Act 2021, was not framed, not introduced in Parliament of some other country. It was our Parliament. Our Finance Minister has introduced it. So this issue of particularly the two circulars extending the time limit, that is on 31st of March and on 27th of April under the TOLA. Those were not only unfair, but completely illegal. And high courts have taken a completely judicious, lawful view. Not one high court, one after another. All those learned judges, vicharpatis, there was no reason that they could be faulted. I will go into the detail of the Honorable Supreme Court judgment, and I will also point out, as in one breath, the judgment says one thing, they say that we fully agree with the High Court orders. Then they say something else. They take some other conclusion. This cannot happen in a democracy like India. And then the Honorable Supreme Court has said that they are exercising their powers, which are with them under Article 142 of the Constitution. Means you see, many times it happens that whatever cases are pending in various high courts, these are brought to the Supreme Court. But this was also not done. They said that so there is only one basic appeal before us, that is against Allahabad High Court. Other appeals are not before us, but we don't want that other appeal should come to us, should be filed before us by the department. In the number of cases, it was verbally cited by the ASG, Additional Solicitor General, in the court that there are 90,000 cases involved. Now, these 90,000 cases, there is no veracity. And it has not been given to the Honorable Supreme Court in writing. It was only verbally stated. At one place, they say 9,000 cases. Another place, they say 90,000 assessments. I am unable to understand as to 9,000 cases, how there could be 90,000 notices. Because in the pre-amendment era, what could be reopened was 4 years and 6 years. Assuming that one case is of say highest number of years, 6 years, even then 6 years into 9,000, if all cases were to be reopened, becomes only 54,000. And bona fide mistake, even if it is a bona fide mistake, for that, can the government be rewarded for such mistake? I had occasion to contest in the Honorable Income Tax Tribunal, and such cases were also dealt by the Honorable High Court, Calcutta. That in case the proper opportunity was not given to the SSC, that is natural justice, then the tribunal cannot make it good. They cannot say in the tribunal of the High Court that gives another opportunity. The tribunal and High Court, they have clearly said no, second inning cannot be permitted. Then you see, in this context, I come to a very interesting case, that is the Honorable Supreme Court case. Is the Pursuit of Watery Works Limited versus ITO, that was reported in 106 ITR, page 1. And the judgment was delivered by two-member bench headed by Honorable Justice H.R. Khanna. and this judgment was pronounced following another Supreme Court judgment, that was CIT versus Bhanji Lavji. So what was held? The Honorable Supreme Court in Parshuram Potri said that taxes are the price that is paid for civilization. We all agree, no problem. It is essential that those, you see, this is most important thing. It is essential that those who are entrusted with the task of calculating and realizing that price for civilization, should familiarize themselves with the relevant provisions and become well versed with the law on this subject. If the officials of the Income Tax Department, be it of any level, including CBDT, if they say that I was not aware about it, Baba, you made the law, you amended the law, Finance Act was routed, amendments are routed through you, how you can say that we are not aware? And the Supreme Court in Parshuram Potri has said further in the same very decision that any remittance on their part can only be at the cost of national exchequer and must necessarily result in loss of revenue. The burden is to be borne by the exchequer and not by the taxpayer. And at the same time, it has to be borne in mind that the policy of law is that there must be a point of finality in all legal proceedings. We cannot keep it open. And then you see, we have got Article 265 of the Constitution. That article says that no tax can be levied except by the authority of law. Now, if this 142 article order, which has been pronounced by the Honorable Supreme Court with due respect, can we ignore what Article 265 says? Can we ignore what are the provisions of law? Can we ignore what is the Finance Act 2021, which is in due knowledge of the authorities of the Income Tax Department, including the Central Board of Direct Taxes? So see, these cases, I'm afraid, these were Parshuram Potri was not cited before the Honorable Supreme Court. We now come to the order of the Honorable Supreme Court. This runs, you see, in as many as 34 pages and 12 paragraphs. Only one case, mainly Ashish Agarwal is the respondent, Union of India is the appellant. Before the Supreme Court, some other appeals have also been mentioned, but those were all mostly from Allahabad High Court. The Honorable Supreme Court, in its own judgment, has said that the various high courts, other than Allahabad High Court, Delhi, Rajasthan, Calcutta, Madras, and Bombay, they had also given similar decision that the notices issued after 31st March 2021 under the old law, those are paid in law. And some cases have been also mentioned, some Calcutta cases also been mentioned, Calcutta High Court cases in this Bagdia Properties case and Manoj Jain's case, and 8 cases have been referred to. You see, in many places in the judgment, the Honorable Supreme Court says that the notice is issued after 1/4/2021. In my humble submission, this should have been on or after 1st April 2021. Because on 1st April, also many more notices might have issued. Then the Honorable Supreme Court has reproduced the provisions, that is the pre-2021 amendment and post-2021 amendment. They also talked of time limit for issue of notice. They talked of sanction of the issue of notice. And in para 3.2, the Supreme Court itself says the Parliament introduced reformative changes to section 147 to 151 of the Income Tax Act 1961, governing reassessment proceedings by way of Finance Act 2021, which was passed on 28th March 2021. Passed in the Finance Act 21, which are agenda. Then they reproduced the sections. The most interesting part is section 149, time limit for notice. And there in 149(1)(b), interestingly, provision has been added. You see, firstly, the earlier one is also not lengthy, so I read it for your ready reference. 149 subsection 1 says, no notice under section 148 shall be issued for the relevant assessment year if 3 years have elapsed from the end of relevant assessment year, unless the case falls under clause B. B says if 3 years, but not more than 10 years have elapsed from the end of relevant assessment year, unless the assessing officer has in his possession books of account or other documents or evidence which reveal that the income chargeable to tax represented in the form of asset, that's cumulative. It's not only the books of account or documents, income chargeable to tax, represented in the form of asset which has escaped assessment amounts to or is likely to amount to 50 lakhs rupees or more for that year. So that was 149(1), small a, small b. Now, the provision below subsection B that says that provided that no notice under section 148 shall be issued at any time in a case for the relevant assessment year beginning on or after 1st April 21, if such notice could not have been issued at that time on account of being beyond the time limit specified under the provisions of clause B of subsection 1 of this section, as they stood immediately before the commencement of the Finance Act 2021. So this is clear. Now, when we are already at this point, let us also analyze about the reopening of assessments for different assessment years. Say assessment year 2013, 2013, 14, 14, 15. Now the time limit we are all aware. The section 149(1) prior to amendment by Finance Act 2021, it was maximum 6 years, unless until it related to the foreign transactions. So 13, 14, 14, 15 notices could not be issued even on 31st March, after 31st March 21, because that was the last day. So if we are analyzing also the impact of this judgment and the aftermath of this judgment. So assessment of 13, 14, assessment of 14, 15 is gone. Means no notice can be issued for that. If any notices have been issued on or after 1st April 21, those are all illegal and inconsistent with the proviso, first proviso to section 149 1B. Now we proceed further. Assessment year 2015-16. So 15-16 also the time limit was 6 years from the end of assessment year. 15-16 means we have to calculate from 31st March 16. 6 years are completed on 31st March 22. What our Honorable Supreme Court says that all those notices which were issued wrongly under section 148 will be treated, will be deemed to be notices under section 148A. That means not 148, 148 is gone. Now under section 148A, the officers in all those so-called 90,000 cases, they will reveal the information or material which the department has got within 30 days from the date of the order of the Honorable Supreme Court, that is from 4th May 2022. They have been directed by the Honorable Supreme Court that they have to reveal the information and the material which they have got. And that information and material has to be in consonance with the provisions of law. So if we, so 15-16, suppose they supply us some information or some material now. Now means we are in the month of May now. And we respond to that. That is already barred by limitation. 15-6 is already barred by limitation. Because Supreme Court does not save the time limitation. If those are barred by limitation, then whether a notice under section 148 can be issued today or in this month or next month. After we respond, we were supposed to respond to that information or the material which they supplied to us within 2 weeks as per the Supreme Court direction. So, as a student of law, my considered opinion is that even no notice can be issued for the assessment of 15-16, even by taking shelter of the order of the Honorable Supreme Court, because the time has gone. So far, the other years are concerned, that is 16, 17, 17, 18, 18, 19, those which are within 3 years, and if the basic requirement is fulfilled, there are also conditions, I need not tell you. If those conditions are fulfilled, then 3 assessment notice can be issued. Prior to that, as I just read, there has to be escaped income of more than 50 lakhs, and that is to be represented by asset. And the asset has also been defined what are the assets which are within the 4 walls of law. So even when any notice is received for these years, means 16, 17, 17, 18, even then on getting the information from the department and the material, whatever they supply, we should carefully respond to that. Sometimes you see they say that you had a turnover of 2 crore. So the receipt, essentially any receipt, any quantum of receipt or turnover is not necessarily my income. What law provides is that more than 50 lakhs rupees has to be my income. Just on the basis of any receipt for the sake of argument, they cannot say that that is my undisclosed income or escaped income. So these issues we should bear in mind while dealing with any information or so-called material which they provide to us. You see, in some cases where my clients have received the notices, what is the information? They only reproduce the information which they have got through inside portal. The law provides that the ITO, the officer may inquire, but the Supreme Court has said that that is his sweet will, whether he chooses to inquire or not chooses to inquire. So you see, that leeway has been given to the officers that not necessarily they are required to inquire. Now you see, without inquiring, without going into the detail, in every case, wherever they have got any information, they will say that your income has escaped assessment. So we are reopening your case. So this kind of mechanical action without really going into detail, you see, the income tax department, with due respect, I suggest that there are many virtues in the functioning of our courts. Even the lower courts, they are following certain systems and certain procedures. So we should learn from them. And what kind of training is being conducted? I'm aware, I visited the Nagpur Institute, NADT. But otherwise, for other officers, those who are promoted, what kind of training is being conducted? There is a big question mark. The Supreme Court, as I told to you in Parsuram Pottery's case, they have said that they must know what they are going to implement. They must know that law. Before appointing any officer, say inspector, ITO, AC, DC, they should be properly tested. They should be properly equipped with knowledge, not only of the Income Tax Act, but also of the other laws. Like law of evidence is very important. Natural justice is very important. I suggested this when I visited NADT. I discussed with the respected Director General of training there.
Naranjan sir, just an intervention, just intervening. Actually, can you just focus on what responses which you can guide the client? See, the weaknesses of income tax is well known, and you have suffered a lot. I have not, I am on the other side. But the question is, people, the Supreme Court, what they have done is exceptional, we all know. Ultimately, what to do now? How to go about it? How to defend? That would be the focus. I mean, if you can keep it to that, then perhaps the members will benefit more.
Yes,
But how to respond, like you said, that now you have to respond, what to do, how to go, but they have to conduct an inquiry, and a few things are there. So when it just, let the young members know that suppose they have to guide, because you are a senior person, you have suffered the income tax much, but what to do? Now that there's a law, we have to do something. So if you can confine that, then after that, we can ask Mr. Surana also in 10 minutes so that discussions can follow later.
Some other paragraphs of the Honorable Supreme Court order are also very relevant for our discussion. They have tried to compare between the old provisions of section 147 to 151 and the new provisions, substituted provisions substituted by the Finance Act 2021. Which in para 6.1, the Honorable Supreme Court says that pre-Finance Act 2021, the reopening was permissible for a maximum period up to 6 years. And in some cases, beyond even 6 years, leading to uncertainty for a considerable time. Therefore, Parliament thought it fit to amend the Income Tax Act to simplify the tax administration. That is the one reason. To simplify the tax administration, ease compliances, and reduce litigation. This is threefold object, as noted by the Honorable Supreme Court. Therefore, with a view to achieve the shared objects by the Finance Act 2021, Section 147 to 149, and section 151 have been substituted. And immediate next para, under the substituted provisions of the Income Tax Act, no notice under section 148 of the Act can be issued without following the procedure prescribed under section 148A of the Act. Along with the notice under section 148, the assessing officer is required to serve the order passed under section 148A of the IT Act. Section 148A of the IT Act is a new provision which is in the nature of a condition precedent. Introduction of section 148A of the IT Act can thus be said to be a game changer with an aim to achieve the ultimate object of simplifying the tax administration, easy compliances, and reduce litigation. So Supreme Court has noted that 148A is a game changer. But prior to pre-Finance Act 2021, while reopening an assessment, the procedure of giving the reasons for reopening and an opportunity to the SSC and the decision of the objectives were required to be followed as per the judgment of Supreme Court in JK and Drive South. And it also says that all safeguards are provided before issue of notice under section 148. At every stage, the prior approval of specified authority is required, even for conducting inquiry under section 148A, small a, only in a case where the assessing officer is of the opinion that before any notice is issued and an opportunity to be given to the SSC, there is a requirement of conducting an inquiry, the assessing officer may do so, or conduct an inquiry. So that they have said that it is the optional one. Then in para 7, it says the new provisions substituted by the Finance Act being remedial. Interesting comment. The new provisions being remedial and benevolent in nature. Benevolent for what? Benevolent is not for government. Benevolent is always for the public. Remedial and benevolent in nature and substituted with a specific aim and object to protect the rights and interests of assessees, as well as, and the same being in public interest. I am reading, sir, from para 7 of the Supreme Court judgment. Benefit of new provisions relating to past assessment years, provided section 148 notice has been issued on complete agreement. The Honorable Supreme Court said that we are in complete agreement with the view taken by the various high courts in holding so. And then you see the immediate next para 8 says that, however, at the same time, the judgments of several high court would result in no reassessment proceedings at all.
Yes, sir. My request is criticizing Supreme Court judgment. We can go on endlessly because they have been worked 140. Basically, what idea is that what to go beyond? We can keep on telling. We know the judgment is exceptional. So I would request you to complete in 5 minutes, please, because then we can focus that now this has come. It is a fait accompli. What to do? I mean, now that what will proceedings will start. So, I'm aware that this judgment under 142.1 is exceptional. So I'm just confined to that, What I would suggest is that let the professionals, about 150 who are now listening to it, should know that, look, this has happened. Now, how to go about it. If you can do that, it will be better. I have my request.
Okay, sir. But basically, why I was highlighting some portions of the judgment of the Honorable Supreme Court, that with reasonable emphasis, what has been stated, the last paragraph I read, in one breath, the Honorable Supreme Court says that we fully agree with what high courts have held. We also agree with the purposes for which the sections 147 to 151 substituted. And then they say that leeway should be given to the department. Now this question police को complaint करता है, तो पुलिस आता है जब चोर चला जाता है ना सर,
this judgment under 142
500 मीटर दूर जब चोर चला जाता है तब पुलिस आता है.
You see, question is, as I said, we can do that, but ultimately the professionals would like to know that now this has happened, how do I go with my client? We can go on endlessly. This judgment is indefensible. To my mind, because of Supreme Court, nobody can question them. 141 invocation itself showed that the government told them to do it. But question is now endlessly, I would suggest that if you can confine to anything, otherwise, like Mr. Surana said, now that it has happened, what do we do? That
Sir,
is my...
what is happening, Upadhyay Sahab, Chairman, sir? How this 148A proceeding is being conducted? I would like to share, as suggested by you, the practical example. 148A notice is issued by the party. Party is responding. There is a stamped receipt acknowledgement of the department. After 3 days, the party gets a notice under order under section 148A(1)(d) and a notice under section 148, mentioning that notice under section 148A was issued on so and so date and no response received.
Therefore, you have to go for grievance. Then in that case, I will give
Grievance will not help, sir. It is not appealable. Even I cannot file an appeal before the shared appeal or before the tribunal, sir. I have to go only to the High Court. Who will pay for that?
The question is that...
Sir, kindly listen to me. This kind of work is being carried out by the department.
I'm not defending my ex-department. I'm not
It
defending
cannot be permitted.
But
The Chief Commissioner, the Civility and the present Chief Commissioner and other officers should take note of my comment that this kind of situation cannot be permitted.
Now, how do you let your comment go to the CBDT?
We will write to them and it will appear in newspapers.
And then there are certain platforms which have been given to highlight this thing on DTPA platform. They may listen to you. But for this Zoom meeting, I would suggest that, we need to, look, what can we do about it? Otherwise, it will continue like
Sir,
637.
what kind of injustice is being meted? That is not one case. There are many cases where reply is being made. And this order, sir, order under section 148A is required to be passed with the prior approval of the principal commissioner or the chief commissioner. That means even the reply which we made, that is not presented in the file before them. Otherwise, they would not have permitted.
I agree that if the problem of implementation is very difficult, the officers, senior officers do not take action against junior officers. But that is a different forum. What are we discussing today? Are we, what I'm saying that let us confine to the topic today is what now this has happened. Supreme Court has given a very exceptional decision, 142, unheard. Now, question is criticism of department go on. We can always do that. And it is justified. But will it serve any purpose for this Zoom conference? I'm asking you that.
My humble suggestion is to all my colleagues that whenever we get any information or material from the Income Tax Department, in pursuance of the order of the Honorable Supreme Court, we should carefully go through it. They are supposed to provide to us within 30 days.
That's
and
right.
Thereafter, within time permitted, that is 2 weeks, we must respond to that. It is not that we give one response, that then we give another response. That may not be possible. So whatever response we give to those information and material which the department provides to us, that should be like we ask for speaking order, that should also be an acceptable reply so that in appropriate cases the proceedings can be dropped. And then whenever this situation arises and some questions are there at the end of the program, we will deal with that, sir.
That will be better. Thank you. Thank you, Jantab. You have given a very good background of the Supreme Court. Of course, this decision will go down in the history. I will not say because Supreme Court, you cannot say contempt, but 142 and you are trying to bail out the government for the miss they have done, but they have done it. And I told you in my introduction, it was a nudge from the government. You have to bail us out. You have to, and they have bailed out for the reasoning which you have highlighted, which does not stand. When for a Supreme Court to say on this and it is not panchayat. Supreme Court is not panchayat. Supreme Court is the Supreme Court. But now that has happened, what to do through 1 month? Should we start preparing for the reply? How much reply should be prepared? Since this will be with the jurisdictional assessing officer, I believe at present, perhaps this 148 will remain with the jurisdictional assessing officer. What way we can convince him if we get an opportunity to, interact with him like in some cases. Now I will request Mr. S.M. Surana, who is the second speaker, another eminent speaker like Mr. Jain, a lot of experience in litigation, especially in tribunal and other things. to kindly, he may be introduced to the participant, and then he may speak on this topic. Thank you.
Please read the profile of our learning speaker.
Yes.
Dear friend, no necessity of this profile and anything. We know each other. So why should we waste time in profiles?
Okay, sir.
I think that will be better. Upadhyay sir, with your permission.
Yeah, of course. Please go ahead. Please go ahead.
Sir, a digital flower bouquet to see you, sir. Please accept.
Welcome, sir.
I
Thank
accept.
you.
Thank you, sir. Over to you, sir.
Honorable Sri R.S. Upadhyay Sahab, Chairman Sahab, I am very lucky today that under his guardianship I have got the chance to speak on a particular subject. Upadhyay Sahab was the most respected person. I will not say as officer, but as a person, he was the most respected officer because he used to take decisions without any fear and favor. I will give you only one example. You know that this investigation officers, they used to call for number of details in a single inquiry. And people were rather very much annoyed because of all these inquiries. And he was the only officer who issued a circular that you ask only pertinent question, don't issue a notice asking for number of details. And that circular still we quote. And once we quote that circular, the notice is stopped. So we are obliged to Upadhyay Sahab for that circular.
Thank you. Thank you. Thank you for reminding me of that. I'm now retired for 30 months. Thank you.
Maybe,
Please
sir.
go ahead.
But you might have retired, but that letter is not yet retired. That we still take use of that.
You are generous in your praise. You are very generous. Thank you.
Now,
Please.
sir, you have very lucidly analyzed the entire provisions of section 148 right from the beginning when it was amended and finally again amended in 2009 and all that. And then very critically, Narayan Jain has examined this 148 provisions of the Supreme Court judgment. But what Your Honor rightly said is that now what is the impact of this judgment? How to deal with this judgment? Because once the judgment is passed, that judgment under section 1, under Article 141 of the Constitution of India, which says that the judgment of Supreme Court is binding. So when it is binding, it has to be carried out. For that purpose, because there will be some impact of Article 142, I'll just read out Article 142, what it says. The Supreme Court in the exercise of its jurisdiction may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it. And any decree so passed or order so made shall be enforceable throughout the territory of India. Kindly note down, in such manner as may be prescribed by or under the law made by the Parliament, and until provision is that we have so made in such manner as the President may by order so prescribe. So इन्होंने जो law भी बनाया है, how that will be implemented? That will be implemented by making a law of the Parliament or by an ordinance or something like that. Now, whether Supreme Court judgment, which says that there were 90,000 notices issued and there were 9,000 writ petitions filed before the Honorable High Courts, whether this judgment, first we have to look into whether this judgment will apply to 9,000 or 90,000. Now, if you kindly see, there are two. The Supreme Court notes that there are approximately 90,000 notices issued, and out of that, only 9,000 writ petitions were subject matter of writ petitions. Then in para 2.1 it said, we propose to pass an order in exercise of powers under Article 142 of the Constitution of India. The present order shall govern all the other judgments and orders passed by various high courts on the similar issue. So according to Supreme Court, this will apply to the petitions pending or orders passed by the Honorable High Courts. Then my Lord has said in para 11, the present order shall be applicable pan-India. Pan means its presence across the nation. But then they say, and all judgments and order passed by the different high courts on the issue and under which similar notices were issued on after 1/4/2021, issued under section 148 of the Act, are set aside and shall be governed by the present order and shall stand modified to the aforesaid extent. That means, जो orders high court ने पास किए हैं या जो पेंडिंग है जो 9,000 उस पर ये अप्लाई होगा पैन इंडिया. तो माय फर्स्ट इश्यू इज कि ये 148 ए के जो प्रोसीड्यूर सुप्रीम कोर्ट बता रही है वो 9,000 में होगा या 90,000 में होगा. To my mind, this judgment will apply only to 9,000 cases, not 90,000, unless the
CBTT comes to a notification that this judgment will apply to all the 90,000 cases. Therefore, when notice comes from the ITO in respect of 81,000 notices, we may deal it on merits or otherwise. How to deal it, I will come to that later on. But first issue has to be aware that the Supreme Court judgment will not apply to you, because this will not apply to 81,000. So whatever notices are issued under Section 148 after 1/4 or on or after 1/4 2021 are null and void, because that has been issued under the old Act. Because the Honorable Supreme Court, if you see, there are 3(1), they have taken note of all the limitations which were extended by the Honorable CBDT, or so to say by the President by notification. They have taken note of 4 notifications issued on 31/3/2020, 24/6/2020, 31/3/2021, which extended the time up to 30th/4/2021, and 27/4/2021, which extended to 30th June 2021. And the last 2 notifications were subject matter of dispute before the Honorable High Court. And the High Court said that these notifications cannot extend. The old Act goes. So from 1/4/2021, the old Act has gone for all purposes. And this is what in para 7(1) also, the Honorable Supreme Court says that the High Courts were correct in saying that after 31st March 2021, the old Act goes. All actions has to be taken under Section 148A. Therefore, whatever the notices are issued under the old 148 are no longer in existence, they are bad in law. If that be the position, then what happens to 9,000 or 90,000 cases for which notices are issued after 1/4/2021 under Section 148? In this respect, kindly see first proviso to Section 149(1), which says that if any action which has become barred by limitation on 1/4/2021, no action can be taken by the department reopening those cases. Now 13/14, extended time was up to 31st/3/2021. Because the subsequent 2 notifications have been declared to be null and void, not empowered the department to issue notices after 1/4/2021 to 30th/6/2021. That means for 13/14, the last date was 31/3/2021. 148A now issued as per Supreme Court direction. Supreme Court says 149 protection you are getting. Explicitly says that 149 protection you are getting. 149 says if it is barred by limitation, it goes. Therefore, if I receive any notice for 13/14, whether it is above 50 lakhs or below 50 lakhs, because sir, 13/14, original 148, there was no limitation of 50 lakhs or below 50 lakhs. No notice can be issued. And I may quote the Supreme Court judgment earlier in the case of JP Jani, 72 ITR, page 595, and Calcutta High Court, Manikchand Nada, 78 ITR, page 204, where it says that if the limitation has expired before amendment of law, then the amended law will not apply. This amended law, which empowers the department to issue notice for 10 years, comes into effect from 1/4/2021, and the action for 13, 14, and 14, 15 has already expired on 31/3/2021. Therefore, if any notice we receive from the department for assessment at 13, 14, and 14, 5, 15, we will straightly write to the department that this notice is bad in law, ab initio void. Even the department, if suppose, for argument's sake, doesn't drop, then there are 2 options open. One is fight it out on merits and go for regular appeals, and I am 100% sure that the CIT appeal or the tribunal is bound to cancel that order. The second alternative is we can go to it directly that this notice is bad in law in view of Section 149(1) first proviso as well as in view of the Supreme Court judgment. So 13, 14, and 14, 15 goes. Now for 15, 16, 16, 17, 17, 18, what happens? If it is below 50 lakhs, then the amended provisions will apply only and only if the specified conditions mentioned in Section 149(1) are satisfied. That is, the department is in possession of books of accounts or any document or evidence which suggests that there is escapement of income of over 50 lakhs. In all 148 notices for these years, for which already 148 is received, which were the subject matter of dispute before the Honorable Supreme Court. In that the amount is mentioned and there is no mention of any evidence or book. Those notices may also not stand. Of course, the department can issue new notice under section 148A for assessment in 15, 16, 16, 17, 17, 18. Because with due respect to Narayan, according to me, 15, 16 was not barred by limitation on 31st March 2021, because under the old law also the 6 years time was there. 6 year time means for 15, 16, the department could have issued notice under section 148 by 31st 2022. And on 1/4/2021, the new law came into effect. So once the new law has come into effect, at that time, the proceedings were not barred by limitation. When the proceedings were not barred by limitation, then yes, the department can take action and issue notice under section 148A. But the amount should be more than 50 lakhs and it should fulfill the criteria mentioned in section 149(1)(b). But below 50 lakhs, since the limitation is given in section 149(1)(1)(a), that if it is below 50 lakhs, it cannot be reopened for more than 3 years. Therefore, if we receive any notice where the quantum involved is less than 50 lakhs, those also goes, and similar proceedings we have to take either before the Honorable High Court by way of writ petition, or we can, if we don't want to spend that money, we can take it legally before the IT and thereafter before the CIT bill and the plan. I am sure we will get the relief. Now there is another case. What happens to 1819? Notice under section 148 was issued for 1819 on 1st April 2021 or in between 1st April to 30th June 2021. At that time, say a 3 years period was available because that notice could have been issued by 31st March 2022. Now the Honorable Supreme Court says that from 4/5/2000 information as well as material, and the SSC has to reply within 2 weeks, and thereafter the 1D. And if they drop, fine. If they initiate, then notice under section 148 is to be issued. Now, friends, you come to section 149 again. 149 says that if the income is below 50 lakhs, then notice under section 148 can be issued only within 3 years. 31st March 2022. He has to count these 3 years as on the date of issue of notice under section 148. If he counts today, then 1819 is also gone. Because 1819, the time for issue of notice under section 148 for the income below 50 lakhs expires on 31st March 2022. And when that time is expired, then as on the date when they are issuing the notice under section 148, they cannot issue for 1819 also. So in my humble reading of the law is that they cannot issue notice under section 1819 also if the income is below 50 lakhs. Now, the department is giving notice under section 148A now, and we have to respond. The case in that is that the AO is to issue notice under section 148 within after the end of the month in which our reply is received, after the end of 1 month in which the reply is received. That means suppose on 4th May they gave a notice under section 148A along with the information and that material, then we can reply by 3rd June. Now we reply on 3rd June. They will get time up to 31st July to drop the proceedings or to issue notice under section 148. Because we get time up to 2 weeks and we have to reply by 17th of June. Now, if the department gives us a notice say on 21st of May and we reply on 31st of May, then the department gets the time only up to 30th June. But the problem with the department is that their computer will show that this is the 30 days expiring, this is the SSC's 14 days expired. So they will only pass the order by 31st July. And if they don't pass the order by 30th June, you are in win-win situation because you have filed the reply on 31st May and they have to pass the order by 30th June. So that has to be taken care of. Number 2, the information was to be provided under section 148AB. Supreme Court has qualified, expressly qualified that not only that you have to give the information, you have to also give the material along with the information. Now it will be a difficult situation for the department because we all are aware that the information is being supplied on the net. by different department officers, and when it is supplied by on net, but this is the statement of somebody who has given this statement, or some document is found in the course of search of somebody. So your name is found in those papers. To collect those materials for the department will be very difficult. We have to hammer that you have supplied the information, but you should also give the material in view of the Supreme Court judgment. You are bound to give within 30 days. That reply must contain that statement of ours, that the statement has to be given by you. The information has to be given by you along with the material itself in view of the Supreme Court judgment. Now, next point, which is also very important point, that notice under section 148A issued. The Honorable Supreme Court says that the high courts were correct in holding that all those notices were bad in law. Now those notices are bad in law, but this has been converted into 148A. As rightly said by Narayan, that the Supreme Court is only to interpret the law. Supreme Court cannot make the law. But here Supreme Court has made the law by taking shelter of something or this mistake and all that. And then, but the Supreme Court was wise enough, I should say. They have made the law with the consensus of the parties. And they said that we propose to pass this order. And all the parties involved have given the consensus. So if that is the position, we cannot fault with the judgment of the Honorable Supreme Court, because it is on your consensus, not the judgment of the Supreme Court. Supreme Court altered the law because you wanted this interpretation. But in my opinion, this judgment, people say that go for review. I say this judgment is most friendly judgment for the SSC. Because 13, 14, 14, 15, 80% of the cases involved are 13, 14, 14, 15. At least balance cases, I leave 1 or 2% leverage I'll give, are related to 15, 16, 16, 17, 17, 18, 18, 19, where the involvement is less than 50 lakhs. So 98% cases goes. Our assessors will be benefited. Why should we worry that, friends, the judgment was not good or judgment should be criticized? I always appreciate this judgment, that yes, this judgment is essentially friendly and this judgment should not be challenged by anybody. And in any case, if some judgment is given under Article 142, then nobody has got the right to dispute that judgment, particularly the judgment is by consensus. I can cite one judgment of Honorable Justice Buckley, sitting in Bombay High Court. He said that Privy Council has given a judgment. He was disagreeing with that judgment, but then what he quoted, I am unable to adduce any reason to show that the decision which I am about to pronounce is right. On the contrary, if I were free to follow my own opinion, my own powers of reasoning, as such they are, I would say that is wrong. But I am bound by authority, which of course is my duty to follow. And following authority, I feel bound to pronounce the judgment which I am about to deliver. So he said, I have to give the judgment because I have to follow the judgment. Now another case is that this 148AB is to be treated as if it is issued on 4th of May, 2022. All right, we will treat that. Which law will apply? The law as amended by the Finance Act 2022 or the law as existed in Finance Act 2021? This question is because Finance Act 2022 changed the definition of information. Earlier in 2021, information, the assessment can be reopened on the basis of information. What was the information? Flagged in the risk management strategy of the department or final audit objection. And 2022, they have included events also or entries in the books of accounts also, all those things. Supreme Court has explicitly said that the law as existed in Finance Act 2021, that notice has to be treated as if it is issued under Finance Act 2021. That means information should be flagged or there should be final audit objection. When the information comes to you in 148AB, which the Supreme Court has said, the assessing officer to give it to you. Whether that information is flagged information or whether that information is final audit objection of CAG. If that is not there, we have the option either to go to the High Court or to fight it in normal procedure. But I am sure that in view of the Supreme Court judgment, specifically telling that the notice is issued under Finance Act 2021, all those 148 notices as to be treated as 148B. Only the extension is given for giving the reply of 30 days, because if that notice is treated under Section 148B when it was issued, then that 30 days, 7 days, that is already expired. So Supreme Court said that all right, 148B as on the date of issue of notice, but the limitation for giving the reply is extended by 30 days and reply by 20 days. The notice is issued in 2021, April itself or May itself or June itself. Therefore, Finance Act 2021, only to flagged information, the balance information goes. If that be the position, I think we should dispute that also in that notice. Another mistake the department is going to commit, I can tell you for guarantee, you will see whatever the notices are coming. The notice under Section 148A is issued in April 2021, and now 148A reply we are giving, and reply thereafter they will issue 148. Now what they will do is that for assessment year 18, 19, 17, 18, by treating that notice, the approval of the specified authority I have seen is from Principal Commissioner of Income Tax. But when they are giving notice for 18, 19 or 17, 18, because at that time that old act was extended, that approval has to be now from the Chief Commissioner of Income Tax or Principal Chief Commissioner of Income Tax, because 151 the Supreme Court has not covered. Supreme Court has covered only 149. So 151 limitation is that if 3 years are expired on the date of issue of 148, approval has to be from the Chief Commissioner. And I have seen one or two notices has come to me that the approval has come from the Principal Commissioner. So that is also a big case. As a professional, you must take care of that. So, Upadhyaya Sahab, those are the gates, according to me, in the Finance Act.
I must say that you have really like an advocate. You see, I must tell you, you are now realizing that don't go on merit, fight on jurisdiction.
You know,
This is
sir.
your core competence. You always go as advocate. Don't be a CA. Let me tell you, all my people listening, if you are a CA, you will lose with the department. Be a Shakuni, fight on jurisdiction. This point, that point, whether this applies, whether this approval applies, only come to merit. Let the department come on merit. You keep on bringing on record all those judicial issues. And law always says, advocate will always never come on merit. You say, go on jurisdiction. And then then you, even if the person, the tribunal or the CIT appeal ignores the jurisdiction, advocate makes him so weak that he gives decision on merit in his favor. After all, he has raised so many objections. So what I'm saying here is, what judgment he has praised 142.1. Narayan Jain is a more sensitive man. He is upset that you have troubled so many people. But I will not go because Supreme Court has passed the judgment 142.1 real this thing. Basic idea is now, to my friends who are listening, just question every step on law. Don't give reply on merit unless forced. And always keep on repeating, this is missing, this is missing, this is missing. It may help you in the writ, it may help you in the CIT appeal. Some CIT appeals are reasonable people. So this is the basic aftermath, that law should be hit. Be an advocate, less CA. That is the only way out. And as I said, ये जो चक्रव्यूह है ना, उसमें शिकारी कुछ शिकार हो जाएगा. You know, the Supreme Court का. And I have a feeling that over a period of time, like he said, you can't go beyond a particular limit, 50 lakhs and all. That Supreme Court has restored. Many will go. ये जो है ना, जो ये खेल में ना, अगर आप उनको उलझा दोगे, ये उलझ जाएंगे. So Mr. Surana has highlighted, Narayan Jain Sahab, it is good because he is a law guy. What is this judgment? You are supposed to give judgment on law, and you are making a law. So Narayan Jain Sahab's emotional response is good, but ultimately you have to. If you don't look at the tiger, it will not go away. You will have to face it. So how to face it? How to bluff it? So I will now ask questions are there. So I would say that the judgment has come from Supreme Court. Look at the positive side. Start preparing for the reply, and reply should make a checklist. Whether this has been followed, whether this hasn't followed, whether this is there. Make a checklist, and then when your client comes, checklist ये तो हुआ नहीं, चलो इस पे क्वेश्चन करते हैं, इस पे क्वेश्चन करते हैं, ये अप्रूवल पे करेंगे, ये ईयर पे करेंगे, अमाउंट पे करेंगे, ये उसमें करेंगे. 22 का जो है आपका इंफॉर्मेशन है, इंफॉर्मेशन अगर if you are getting from investigation wing, I mean, what I'm saying is कि you have to prepare a checklist of basic jurisdictional objections, and merit, of course, you can come later. You can always hear it out. So now if there are some questions, I'm sure Narayan Jain Sahab and Surana Sahab will guide these people, 160 people who are still glued to this, listening to the thing. There's a questions, let Mr. Agarwal, read the questions, and both of them can respond. Mr. Agarwal.
Please read the question from the chat box if there is any.
I believe the latest question has been asked by Amit Agarwal. It's a big one. I would request Amit Bhaiya to unmute himself. Amit Bhaiya. Hello. Amit Bhaiya.
Sir, this is Amit. Sir, you just mentioned that the limitation of 3 years will have to be applied from the date of issue of notice under section 148 now after 4th of May 2022. Sir, can we apply the same logic for the assessment year 15-16? Because first proviso to section 149, they say that the period of 6 years will also apply in for pre-amended laws in respect of all notices issued under section 148, even under the amended laws.
You see, Amit, what you say is that 15-16 whether it can be applied.
Yes.
Just think one thing. What 149 says is, proviso first 149 says is that if as on 31st March 2021, limitation is expired, no action can be taken after that, then naturally the assessment cannot be reopened. Now up to 14-15, I can say 15 means 31st March 2021, that up to that date notice could have been issued. Thereafter it cannot be issued. But 15-16, new law has come on 1/4/2021. So you now forget the old law.
Yes.
You cannot bring into picture or discuss that old law anymore. Now under the new law, whether 15-16 can be reopened or not.
Yes, sir.
Because that notice issued under section 148, even for assessment in 15-16 at that time, in April 2021, has been declared to be null and void by the Supreme Court.
Right, sir.
That is 148A notice now. And
Right.
148A notice could have been issued even in April 2021 for 15-16.
Right, sir.
So according to me, that 15-16 will survive.
So then
And you
first
can-
proviso will become redundant, sir.
How?
First proviso, even if
just read that first proviso. First
Yes.
proviso says, kindly read that.
yes.
Chairman sir, if I can add.
Yeah, of course, both of you are there, batting from the two sides.
Yeah, sir. देखिए, Supreme Court firstly does not mention any section 148A. They only say that department will provide us the information and the material, if any. They do not say that it will be in the form of 148A, though the basic crux is the same, but the section 148A is not mentioned. They say that whatever notices have been issued under 148 will be deemed as notice under section 148A. Secondly, now, sir, if any notice for 15-16 issued now, even if the department is giving us the information and the material, so the date is already gone. How they can issue the notice now in the month of May 2022 for assessment year 15-16? They cannot, sir, in my humble opinion.
Yeah, Amit's reply.
Ramit, I am just reading out. Provided that no notice under section 148 shall be issued at any time in a case for relevant assessment year beginning on or before 1st April 2021. पढ़ लिया भाई?
Amit Bhaiya, please unmute.
Yes, sir.
148 or 153 or 153 could not have been issued at that time on account of being beyond time limit specified under section B of 1A of this section or section 153 or 153C. तो ये बोल रहे हैं कि साहब आपको अगर 1 अप्रैल 2021 को कोई नोटिस इशू हुआ है, उस टाइम अगर कोई नोटिस इशू करते तो टाइम बाद होता, तो आप कोई इशू नहीं कर सकते। तो क्या 15/16 का 1/4/2021 को 148 टाइम बाद हो गया था क्या? इट इज ओनली माय क्वेश्चन टू यू।
सर 2022 में हो गया, 31 मार्च 2022 को टाइम बाद हो गया।
आप 2022 की बात मत करो, प्रोविजो की बात करो। वो बोल रहा है कि
एक तो अभी मई में नोटिस इशू करेगा ना। नोटिस नाउ
वी में डिफर, बट मेरी बात तो सुनो आप। वी में डिफर 1/4/2021 को टाइम बाद हो गया था क्या? ये सेक्शन बोल रहा है और सुप्रीम कोर्ट बोल रहा है कि 149 का प्रोटेक्शन मिलेगा। बस टाइम ऑन दैट ओनली।
6 इयर्स का टाइम है ना, वो तो 31 मार्च 2022 को खत्म हो चुका है।
6
नोटिस अभी इशू होना है।
6 इयर्स की बात ही खत्म हो गई। अरे 6 इयर्स की बात तो 1/4/2021 को खत्म हो गई। सुप्रीम कोर्ट बोल रही है पुराना कानून खत्म 1/4/21 को। नए कानून में कहाँ 6 साल है?
हाँ तो 2022 तक के हो जाएगा ना काम खत्म।
नए कानून में है। उपाध्याय साहब आप जरा कमेंट कीजिए इसमें। नए कानून तो है नहीं 1/4/21 के बाद में।
Yes, one from Finance Act 2021, that amount, the number of years which you can touch has been reduced. So that 6 years was earlier, but now it has been reduced. It was reduced to I think 3 years, which was now made to 4 years by Finance Act 22.
3 years or 10 years?
10 years. 10 years. That is because when you are a high ceiling. So as I said, the checklist has to be prepared of so many things.
15/16 का अगर 50 लाख से नीचे है तो वैसे ही चला गया। व्हाट वी आर डिस्कसिंग इज कि 50 लाख से ऊपर है तो 15/16 का हो सकता है क्या? आई एम ऑन दैट ओनली एंड अकॉर्डिंग टू मी 15/16 का 50 लाख से ऊपर है तो 31/3/26 तक हो सकता है, नॉट ओनली 31/3/22। दिस इज माय रीडिंग ऑफ कोर्स।
Sir, I have a question. If we are done with the 15/16 debate, which was my first question. Hello.
Yeah, please go ahead, Priyanka ji.
Sir, another question is, asset था as on April 21, but April 22 से expenditure को भी कर दिया है, तो can the department take the plea कि the definition of expenditure etc. has been included and it can be used retrospectively?
No, it cannot be used. Supreme Court has explicitly said that Finance Act 2021 में जो provision है वो apply होंगे, तो उसमें information का जो है खाली flagged and then audit objection. They cannot take shelter of 2022 now.
Thank you, sir. एक और question, sir. 142 का जो power Supreme Court ने use किया है, that says that and all the procedures as prescribed by the law. तो अगर 148A मान रहे हैं, तो 148A says to conduct an inquiry on the information. तो इन्फॉर्मेशन की इंक्वायरी तो वो नहीं कर पाया, वो आपको मटेरियल दे देगा, इन्फॉर्मेशन दे देगा अगर है, लेट्स से, तो अब क्या इंक्वायरी पोस्ट करते वो इनवैलिड नहीं हो जाता?
आपको जजमेंट की बात बताता हूं कि सुप्रीम कोर्ट के सामने जब इश्यू आया 148A की बात कर रहे हैं आप। हाँ, वो बोल रहा है असेसिंग ऑफिसर सेल काइंडली इश्यूइंग एनी नोटिस अंडर सेक्शन 148 कंडक्ट एनी इंक्वायरी,
तो इफ रिक्वायर्ड में वो फाइट करेगा।
बात सुनिए, अब ऊपर में बोल रहा है सेल, इसका मतलब हुआ कि आईटी को इंक्वायरी करना चाहिए अगर ये इन्फॉर्मेशन, लेकिन सुप्रीम कोर्ट ने इसको डाइल्यूट कर दिया है। सुप्रीम कोर्ट बोल रहा है कि ये 148A का जो इंक्वायरी है इसको हम अभी इसको अबैंडन करते हैं, इस पर्टिकुलर केसेस के लिए हम बोलते हैं उसकी दरकार नहीं है। फिर साथ में उन्होंने जोड़ दिया है कि इफ रिक्वायर्ड लिखा है तो उससे करने की दरकार भी नहीं है। तो दिस इज डेंजरस पार्ट ऑफ द ऑर्डर, जो सुप्रीम कोर्ट को बोलने की दरकार भी नहीं थी, वो डिसीजन में भी नहीं था। दे कुड हैव सिंपली सेड दैट किसी का 148A का इंक्वायरी इसमें पोस्टपोन करते हैं, इसमें करते हैं फॉर वन टाइम पीरियड, लेकिन उन्होंने सेकंड किसी और बोल दिया है, सो दैट अनफॉर्चुनेट एंड एप्रोप्रिएट टाइम में कभी भी डिस्कशन में आएगा, then we will say that this inquiry was also mandatory, should have made the inquiry when information policy, but now Supreme Court has said that अभी दरकार नहीं है इसको।
अच्छा जी, और सर अगर अपने 15/16 में अगर कोई मटेरियल आता है वो नहीं आता है, तो अगर ऑब्जेक्शन फाइल करते हैं, सो आर यू इन दी ओपिनियन दैट साथ में रिटर्न फाइल करके ऑब्जेक्शन रेज करना चाहिए कि पहले ऑब्जेक्शन रेज करके लेट द डिपार्टमेंट गेट बैक टू यू गिविंग अ रिप्लाई एंड देन फाइल
मेरी बात सुनो, रिटर्न फाइल करने का तो पोजीशन होगा ही नहीं जब तक 148 नहीं आएगा,
नोटिस नहीं आएगा। दैट्स राइट,
ओके
जाएगा ही नहीं ना।
अभी ये प्री स्टेज है, प्री कंडीशन है।
148A में भी आप रिप्लाई तब तक मत दीजिए अपनी मेरिट्स की कोई भी, जब तक आपके पास मटेरियल भी नहीं आ जाए, क्योंकि सुप्रीम कोर्ट बोल रहा है ये दे हैव टू गिव द इंफॉर्मेशन एज वेल एज द मटेरियल।
अच्छा,
दे हैव टू कंप्लाई विद दैट। दूसरी बात मैं आपको एक और बताऊं, ये प्रोफेशनल सीक्रेट की बात है कि अगर आपके पास 148 भी आ जाता है तो प्लीज रिटर्न मत भरिए, चिट्ठी दे दीजिए कि मेरे पुराने रिटर्न को रिटर्न ट्रीट करो। मैं बार-बार बोल रहा हूँ।
हाँ, लेकिन वहां कोई पोर्टल में जगह नहीं है कि आप खाली एक चिट्ठी दे दो।
आप मेल भेज दीजिए भाई, मेल भेज दीजिए। और मेरा एक ईस्ट इंडिया बियरिंग कंपनी का ट्रिब्यूनल का ऑर्डर देख लीजिए कि मैंने चिट्ठी दिया, दैट इज सफिशिएंट कंप्लायंस, और आईटीओ ने 142 नोटिस इशू नहीं दिया, इसलिए असेसमेंट इज नल एंड वॉइड।
अच्छा, ठीक है जी, थैंक यू।
Chairman sir, can I take 1 minute?
Yeah,
Chairman,
please
sir.
go ahead. It is for
Yeah.
you people only. I'm just
No, sir. That debate was going on assessment year 15-16. Just I want to add that what Surana is saying very, very correct. Yesterday was there was some dispute and some social media is also circulating. What is the key word in the 149(1) is there at that time that we are missing somewhere. At that time means as for 141 जब वो पहले पुराना वाला रीजन था तो हो सकता था क्या, तो 15-16 हो सकता था उस समय में, तो अभी भी हो सकता है। तो 15-16 अभी टाइम बार्ड होने का कोई 22 को देखने का कोई मतलब ही नहीं है। That is my humble submission.
As I said, there are so many issues on jurisdiction on various dimensions of jurisdiction, time limit, approval. So those should be highlighted because, as I said, don't go on merit straight away. Raise these issues. No, let the assessing officer prevail. Let them not give you opportunity. They are weakening their case. You are strengthening your case as a lawyer. You have to understand you can't force the person's hand, but at least you can prepare a strategy where your client gets justice at some level.
Correct. Right, sir. But timeline is a very substantial thing.
Yeah. You play the game, na? You are, see, the AO is saddled with so many cases. You have maybe 10 clients to handle, 20, 30, 40. उसके बाद 300-400 है. He's in a much worse situation. I get a feeling. So you have an advantage. Plan it well. Prepare a checklist, I would say, of various jurisdictional issues, and then merit. Of course, merit is merit. Well, it varies.
Sir, good afternoon, Damodar Agarwal. सीए दामोदर अग्रवाल। मेरा एक छोटा सा क्वेश्चन, रिप्रेजेंटेड बाय एसेट्स है 50 लाख का। पुराना जो असेसमेंट था, पुराना लो था फाइनेंस बिल 21, उसमें 50 लाख का रिप्रेजेंटेड बाय एसेट्स था, और उसके बाद में फाइनेंस बिल में ये रिप्रेजेंटेड बाय एसेट्स को हटा दिया था। तो हमारे इसमें असेसमेंट प्रोसीडिंग्स में कोई फर्क पड़ेगा क्या?
आप असेसमेंट प्रोसीडिंग्स की कौन सी बात कर रहे हैं
सर? ये तो 40
जो फाइनेंस एक्ट 2021 में है
जी सर,
जो वर्ड्स है वो यूज होंगे, जो अमेंडमेंटेड है वो नहीं होंगे। जैसे मान लीजिए पहले ये था कि 50 लाख था, वो 1 साल में होना चाहिए, इसमें अमेंडमेंट कर दिया।
बिल्डिंग थी ना सर उसमें पहले।
इवेंट असेट भी अगर 3 साल में आपका 1 करोड़ है और 50 लाख से ज्यादा है तो नए फाइनेंस एक्ट 2022 के हिसाब से आपका रीओपन हो सकता है, पुराने में नहीं हो सकता।
पुराने में नहीं।
कोई इवेंट की बात है, वो भी वो बात है कि अगर कंटिन्यूअस 3 साल में है या 2 साल में तो रीओपन हो सकता है 50 लाख, लेकिन पुराने में नहीं हो सकता था 21 में। तो आपको 21 वाला अप्लाई होगा, 22 अप्लाई नहीं होगा, बिकॉज नोटिस अंडर सेक्शन 148 इज इशूड ऑन द बेसिस ऑफ द इंफॉर्मेशन which information was interpreted and mentioned in 148 की information क्या है, खाली flagged और audit objection, that's all.
Okay sir, thank you.
You should also know that this government has been telling we will not do retrospective, we will not do retrospective. So I don't think they will do retrospective. They may have managed they may have nudged the Supreme Court to bail them out, but they will not do retrospective like 22 को 21 से लागू कर देंगे. They will not do it because they have been telling this to the public. No, era of retrospective is gone. So just stick to 21, which needs a PhD. The Finance Act 21 needs the PhD. 22 you can come later. 21 is the break, complete break, a new law.
There was a question from Kothari ji. Kothari ji, please unmute yourself.
Hello. Yes, sir. Audible.
हाँ नमस्कार सर, उपाध्याय सर नमस्कार।
कैसे हैं भाई? मैंने कहा इतना फेमिलियर फेसेस, आज तो सोच रहे थे मिलेंगे, थोड़ा सा गले भी मिलेंगे, डिस्टेंसिंग कम करेंगे। नारायण जी ने वो कहा, हमने कहा चलो मिलने चलते हैं, लेकिन अब दोपहर पता नहीं इतना बढ़िया मौसम है, फिर भी इन्होंने कहा कि चलो अपने अपने घर में ही रहो। चलिए प्लीज गो अहेड।
जी मेरा क्वेश्चन है सुराना जी से जी, जो असेसमेंट रीअसेसमेंट ऑलरेडी ऑर्डर्स पास हो गए हैं उनका क्या होगा?
वेरी गुड क्वेश्चन। पहली बात तो ये है कि मेरे ख्याल से असेसमेंट ऑर्डर पास नहीं हुए, क्योंकि 1 अप्रैल को जो नोटिस इश्यू हुए हैं ना, उसका टाइम बारिंग हो रहा है 31 दिसंबर 2023 में। लेकिन अगर मान लीजिए कोई ऑर्डर पास हुआ, उसका अगर बेस ही इलीगल है, आप बात को समझिए कि उसका अगर नोटिस अंडर सेक्शन 148 ही इलीगल है, जैसा कि सुप्रीम कोर्ट ने बोला है कि 1/4/2001 या उसके उस दिन या उसके बाद के दिन आपका 13/14/14/15 का कोई नोटिस इश्यू हुआ है, that notice has been declared by the Supreme Court also to be not valid. because they have accepted the high courts were correct. Now this issue you can take in two ways. अगर आपने अपील फाइल कर दिया है तो CIT अपील के पास ले जाइए and is bound to accept that the assessment is null and void. अगर अभी तक CIT अपील के पास नहीं गए हैं तो डायरेक्ट रिट में जा सकते हैं कि साहब ये because of the judgment this notice 148 itself was bad, and if the basic jurisdiction is bad then the entire proceedings are bad. आप एक काम करो, एक जजमेंट है PV डोसी 113 ITR पेज 21
जी,
और एक आपका है दीपचंद कोठारी 171 ITR 380. ये बोल रहा है कि जुरिस्डिक्शनल इश्यू को आप किसी भी स्टेज में कहीं भी ले जा सकते हैं.
That is true. That is true. Legal jurisdiction can be taken any time. Administrative में there are some issues.
और सर दीपचंद कोठारी में एक जजमेंट सुप्रीम कोर्ट का रेफर किया है, किरण सिंह वर्सेस चमन पासवान. वो बोलते हैं कि अगर आपका डिग्री हो गया, सब कुछ हो गया, जो डिग्री वाला एग्जीक्यूट करने के लिए आएगा उस टाइम भी आप जुरिस्डिक्शन चैलेंज कर सकते हैं. तो jurisdiction can be disputed at any time before any court.
Legal jurisdiction can only be challenged. Administrative, you can say that this officer is not bad.
Yes.
Law is law. That has to be
Law is
applied.
law, sir.
That has to be stuck. You can't say that department cannot take it. Law will now you have been delayed. Law में there is no delay. And it has to do justice.
सर इस ऑर्डर को क्या ये 263 में वो कर सकते हैं क्या, सेट असाइड?
263 में तो वो क्यों करेगा? नहीं तो इरोनी
एक्सप्लेनेशन 2
आप 264 में जा सकते हैं.
एक्सप्लेनेशन 2 क्लोज डी,
वो उसमें ये बोल रहा है कि
not in accordance with the Supreme Court judgment which is we are now discussing. Ashish Agarwal,
नहीं, आप 264 में जाना पड़ेगा. 263 में फर्स्ट हेडिंग है कि order should be erroneous and prejudicial to interest of revenue and no order can be passed which is prejudicial.
264 में तो मैं जा सकता हूँ, डिपार्टमेंट का पूछ रहा हूँ मैं.
डिपार्टमेंट कुछ नहीं करेगा. डिपार्टमेंट कुछ नहीं करेगा भैया.
ओके.
डिपार्टमेंट भी परेशान होगा, हम आपको बता देते हैं. और अभी आप वो भी घूम रहा होगा, ढूंढते रह जाओगे हो रहा होगा. You have to understand the problem. You see, ये होता है ना कभी-कभी. So what I would, as I said, कि jurisdiction becomes very important. Legal jurisdiction, not administrative. कि भाई मेरा ये AO है, वो तो आजकल रहा भी नहीं faceless में. Legal issues will become very important because of these, judgments and all, and that has to be. और मेरा कहना है जितने भी आर्टिकल आप पढ़ सके, नेट पे देख सके, सबको कंपाइल कर ले, कहाँ क्या इश्यूज रेज कर सकते हैं, which will help your client.
लेटेस्ट एक jurisdiction पे ट्रिब्यूनल का जजमेंट आया KA वायर्स का, उसमें सारे जजमेंट्स कोट किए हुए हैं KA वायर्स. People can see to that.
Adding to what Sonana sir is saying, there is a recent Calcutta High Court judgment also on 6th of May, which has been delivered. इसमें भी मतलब the SSC had not filed the writ petition and he had challenged, and the Honorable Court has directed the assessing officer to go ahead with the Supreme Court judgment. So that is just delivered on 6th of May.
Things are evolving. That means things are evolving. Keep a watch as a professional, because a lot of clients come to you and you, as I say, under promise and over deliver. I always tell every lawyer, under promise and over deliver. Never there करवा देंगे हो जाएगा. Just say, well, see, this is the complications. I am going to do it. I'll fight for you. I will take this ground. Let us see. Anyway, as I say, things are evolving. After 4 तारीख को ये हुआ, 6 को कलकत्ता हाई कोर्ट का जजमेंट आ गया. अभी तमाम आर्टिकल्स आएंगे, नेट पे आएंगे, चेंबर का आएगा, बॉम्बे चार्टर्ड अकाउंटेंट का आएगा. देखते चलिए. But as I said, legal issues will become more important after the judgment. Merit will come later. I think so. Agarwal sahab, I think.
Yes, sir. I think all the queries are resolved.
Yeah, I think so.
There is one Rajat Agarwal. If Rajat ji,
उनका लास्ट कर लीजिए.
लास्ट एक ले लेते हैं सर.
हाँ. अगले बार जरूर, अगले बार चाहे पानी भर से आंधी आए, नारायण जैन को बोलिए कि बढ़िया से करें. चाय समोसा बचाने के लिए नारायण जैन जी जूम करवा दिए. कोई बात नहीं है. चलिए, let that person ask the question.
Rajat ji, please unmute yourself.
आप लोग कॉस्ट कटिंग किए हैं, DTP एक कॉस्ट कटिंग किया है. चलिए, कोई बात नहीं.
सर ये डिपार्टमेंट को अगर 30 डेज से ज्यादा टाइम.
उपाध्याय साहब, आपको जल्दी बुलाने वाले हम, चाय सिंगाड़ा नहीं और भी कुछ खिलाएंगे.
ठीक है.
6 अगस्त को हमारा एनुअल सेमिनार है, उसमें आपको अभी इनवाइट कर रहे हैं.
अभी हमने शुरू में ही कहा कि हमको तो आप इनवाइट भी करते हैं, स्पीकर भी बनाए थे जॉइंट डेवलपमेंट एग्रीमेंट में. भूपेंद्र साहब बोल रहा था, अरे कुछ नहीं होगा, अरे बेचारा लैंड ओनर को इतना रगड़ देगा, बाद में अमेंडमेंट आए. चलिए, लेट अस कम टू द क्वेश्चन.
Rajesh ji, please continue your question.
सर मैं पूछ रहा था कि अगर डिपार्टमेंट 30 डेज में मटेरियल शेयर नहीं कर पाता है तो वो क्या सुप्रीम कोर्ट से क्या परमिशन ले सकते हैं क्या एक्सटेंशन ऑफ टाइम का?
नहीं सुप्रीम कोर्ट ITO नहीं है कि इतना एंटरटेन कर लेगा।
नहीं 30 डेज में तो सर दे नहीं पाएंगे 90,000 केसेस है।
तो वही मैं कह रहा हूँ ना, यू डेवलप योर केस। आप बोलो कि मेरा
आप क्यों चिंता करते हैं भाई उसकी, अपनी चिंता करो, उसकी क्यों चिंता करते हो? अरे वो बाप सुप्रीम कोर्ट में जाएगा, सुप्रीम कोर्ट उसको डंडा मारेगा।
सर
सुप्रीम कोर्ट
पता
ऐसे ही
तो
बहुत
होना
ज्यादा
चाहिए
हेल्प
कि उनके पास क्या रास्ता है, वो रास्ता तो पता रहे अपने को, उनके पास रास्ता है क्या कोई?
रास्ता वो खोजो ना यार।
देखिए
अच्छा,
क्या
ठीक है
है
सर।
कि आई कैन टेल यू वन थिंग दैट रास्ता का क्या है कि दे विल नहीं कर पाए 1 महीना में, तो नहीं। अब आपको एक तो बेल आउट किया, आपका दला इतना हार गए थे, ऊपर से आप कहिए कि हम नहीं कर पा रहे हैं, तो बेचारा किसी के पास जाओगे 4 बार तो कहेगा हो गया बहुत। वैसे जाने का स्कोप दिखता नहीं है। आप तो बस देखते चलो डिपार्टमेंट क्या करता है, आप अपनी तैयारी शुरू कर दो। यू स्टार्ट प्रिपेयरिंग क्या आने वाला है, क्या इशू हमको रेज करना है, आगे ही से बना के रखो। प्री रिटर्न बन के रहता है ना AS AIS 26 में, पूरी तैयारी करके रखिए और आज कीजिए। नहीं देगा समय, खुराना जी हैं, नवाल जी हैं, छुड़ा लेंगे CIT अपील में, नेचुरल जस्टिस ट्रिब्यूनल में तो 100% छूट जाएगा।
सर 30 दिन में नहीं देगा तो वैसे नल एंड वॉइड हो जाएगा।
यस सर। सर एक्सेप्शनल केस ऐसा हो सकता है कि मटेरियल का जवाब SSC 2 वीक में नहीं दे पाए, ऐसा हो सकता है एक्सेप्शनल केस में, तो उस केस में सर डेट मिलेगा क्या, टाइम मिलेगा क्या SSC को?
नहीं मिलेगा। क्यों मिलेगा आपको टाइम? उसको 30 दिन का टाइम मिला है, आपको 2
आप आगे से तैयारी शुरू कीजिए। मैं आपको सही बता रहा हूँ, क्वेश्चनिंग तो आप शुरू कर ही दीजिए। पूरा 10 पहला 2 पे तो मेरे जुरिक्शन पे हो, फिर कीजिए। आप तैयारी शुरू करवाइए। अगर क्लाइंट आपका आ गया है, उसका रिवाइव हो गया है, और अगर वो 90,000 में है, 9,000 में है, तब तो चलिए ठीक है। 90,000 में तो वहां से शुरू कीजिएगा कि हमारे पर लागू ही नहीं होता है, चलो एक नया किस्सा है। तो व्हाट आई एम सेइंग इज स्टार्ट प्रिपेयरिंग योर दिस थिंग। अपना चेकलिस्ट बनाना शुरू कीजिए, पूरा पढ़ लिख के। आई थिंक विद इन अ वीक पूरा डेटा आपके पास आ जाएगा। ये तो कॉन्फ्रेंसेज हैं, आर्टिकल्स हैं, नेट पे इतने चीज आ जाएंगे, यू कैन डिवाइड। और वकील वाला दिमाग लाके चलिएगा, CA वाला नहीं।
चलिए, थैंक यू सर, थैंक यू
सर। सबको पोर्टल अपना चेक करना पड़ेगा। एवरीबॉडी हैज टू कीप वॉच ऑन द पोर्टल।
यस यस यस, पूरा एकदम अलर्ट रहिए।
थैंक यू
सर। 2 महीने हम लोग देखेंगे क्या डेवलपमेंट हो रहा है। we will revisit this issue again on 6th of August.
यस जज साहब, आप ही जीतोगे। ये आप तो एकदम लॉ के हो कि क्या अपना तुम इंटरप्रेट करो, लॉ क्यों बना रहे हो। लेकिन अगर बन गया तो इसमें भी आप ही निकलेंगे आगे, कोई दिक्कत नहीं है। आपका क्लाइंट को थोड़ा सा हाथ पकड़ना पड़ेगा, उसका आंसू थोड़ा पोंछना पड़ेगा, क्योंकि वो तो बेचारा झेल रहा है ना, वो तो सफर कर रहा है। तो उसको कंधे पे हाथ रख के रखिएगा, थोड़ा सा काउंसलिंग करके बताइएगा जरूर। चलिए, I think the person who can give vote of thanks, we have done in a very right time.
एक सेकंड। Thank you, convener sir. First of all, I would like to thank R.S. Upadhyay sir for taking his time out from his busy schedule and deliberating on the very pertinent topic, and also to both our speakers, Mr. Narayan Jain and Mr. S.M. Surana, for very patiently dealing with all the queries and giving their views so that it can be of professional benefit to all of us. We wish to hear from you all soon, and thank you to all the participants for attending this webinar. Thank you so much.
Thank you. Pleasure. Thank you.